for the late start. The accused arrived late.
What's the reason, according to the...
2 and 4, I'm told that there was a delay in prison at Kosimampur regarding the booking out of accused number 2. But it's not precisely clear as to what led to the delay in booking out. So the rest of the accused were waiting for accused number 2 because they have to pick him up at Kosimampur.
Okay, fine.
We will address that issue.
All right.
Then secondly, we have updated the list of exhibits. I've provided my colleagues with the updated list.
Thanks.
The only thing that's new, my lord, it's at number 87 on page 7.
87.
Yes. Number 87 on page 7.
Okay.
It's a bit exhibit XX.
Yeah.
That's the SAP 310 form.
Okay.
Regarding interview with the suspect. It's a form that was handed by Advocate Nisi.
It was handed to you by Mr. Mngmezulu.
Yes.
Right.
At the request of Advocate Nisi.
He says he wants to use it.
Yeah, well, he requested that it be handed up. I suppose he's going to be fair.
Oh, he'll explain.
Yeah,
okay, fine.
At some later stage.
All right.
Then number 88 on page 8.
Yes.
It's exhibit YY.
Right.
This is a letter from Legal Practice Council dated 5 May 2020 confirming the enrollment of Mr. Dominic Mngmezulu as a legal practitioner, which was received by Brigadier Gininda from Mr. Mngmezulu at Pretoria North Police Station on the 23rd of June 2020.
Okay.
It was handed up via Brigadier
Gininda. Okay.
Thirdly, my lord, when we adjourned the proceedings, Brigadier Gininda was under cross-examination by Advocate Mngmezulu, and the further cross-examination stood down at the request of Advocate Mngmezulu.
Okay.
Mshushisilana bekachaza ukuthi kunamaphepha asanda kwakhona ukuthi kunezinto ezithize ezishintshile la ukuthi kunobufakazi buka XX kuneform ukuthi bekade kukhulunywa nabamangalelwa bese kuba nobufakazi buka YY ekuyincwadi ukuthi yasho ukuthi uDominic Mngmezulu ngempela ungummeli ukuthi basazokhuluma nangayo. Enye into futhi uma sigcina nyakenye ummeli uMnumzana Mngmezulu wayekade esabuza uBrigadier Gininda imibuzo uzoqhubeka kusukela lapho.
Okay, where is the brigadier?
It's just outside.
Oh, okay. For record purposes, Mr. Mngmezulu, have you recovered or recuperated from your ailments?
That is correct, my lord.
Okay.
I am fit emotionally, physically, and
okay.
Thanks.
Thanks. Right. For record purposes, Brigadier, do you swear that the further evidence you're going to give will also be the truth and nothing else but the truth?
I just
okay.
Uthi usazokhuluma iqiniso uBrigadier uyaqhubeka kusukela lapho khona.
Yes, Mr. Mngmezulu.
Court business, my lord. Mr. Gininda, on the last occasion, I was asking about the J50s, the warrants of arrest. Do you still remember that?
Yes, I do remember. He spoke about the warrant of arrest of accused 1 and
Usakhumbula umnumzana uDininda ukuthi bekukhulunywa ngephepha eligunyaza ukuboshwa ummangala lokuqala nokwesibini.
Just want to establish, are you aware that that application is governed by Section 43 of the Criminal Procedure Act?
Yes, the application for the J50 warrants, I am aware, my lord.
Uthi uyazi ukuthi umthetho sekelo owabekwa lapho uyilo ukuthi wakhishwa ogunyazayo ukuthi abamangalelwa bangakhishelwa lezo incwadi uyazi ngawo.
Was the applicant brought by yourself or by the state prosecutor?
I've explained, my lord, that there was an indictment. After the indictment, I then made an application in terms of a sworn affidavit to the Boksburg Magistrate Court based on the indictment by the North Gauteng KPP.
Chazile ukuthi kwakade kunencwadi eyikuthi bekade iphuma kuba umphathi wabashushisi yena ke wayenza i-affidavit.
This affidavit it's clear that it is in support of the application for the warrants of arrest.
It is for the application for J50s, my lord, for accused 1 up to 5.
I-affidavit leyo bekade vele ihambiselana nalezo incwadi ezigunyazwa ukuboshwa bonke abamangalelwa kusukela kokuqala kuya kowesihlanu.
So it is your evidence that all 5 accused before this honorable court were arrested on the strength of the warrant of arrest.
Yes, it is.
Bonke abamangalelwa bona baboshwa ngenxa yokuthi bekade kukhishwe leyo ncwadi egunyazayo ukuthi baboshwe.
When looking at the provisions of Section 43, it relates to an application to be brought before a magistrate. And such application is to be brought before the magistrate at which the alleged offense was committed. Do you agree?
I do agree, my lord.
Yavuma ukuthi incwadi lezo zona ezigunyazayo kwamele zikhishwe la ukuthi kusendaweni noma esivinini sala icala lenzakele ngakhona.
So in this case, 636 of 10/2014, it's common cause that it occurred in forced loaders.
Yes,
Correct.
it is. That is correct, my lord.
Iqiniso ukuthi lelicala le 636 10 of 2014 lona liyenzakele eForce Loras.
And we also have courts in forced loaders.
Yes, we do. But Boksburg, my lord, is a.
I'm sorry, sir.
Oh.
Can I please? We are not in a lecture room. Follow my question, because there are technical issues that I'm coming to raise here. I'm saying it's common cause that this alleged offense or this offense was committed in forced loaders. Is that so?
My lord, I've agreed with that, but it will be trying to mislead this court to try and create an impression that Boksburg does not fall within the jurisdiction of forced arrest. That's what I wanted to clarify, and I think Mr Mngmezulu knows that. Boksburg, forced arrest is a district court. In Boksburg, you get the regional court. Within the district of that area, it's one district, my lord. So there's nothing peculiar or unlawful that was done there.
Kuthi-ke ummeli lelicala leli kuyazeka ukuthi liyenzakele eForce Loras futhi eForce Loras kuney'nkantolo. Mayichaza-ke ubrigadier uthi yena yebo zikhona kodwa nkosi enkantolo ngicela ukucacisa lana ukuthi eForce Loras kuney'nkantolo ezingaphansi ama-district court bese iBoksburg nayo iwela khona ngale ngaseForce Loras kula uthola-ke ama-regional courts.
Do you know the rules relating to demarcation
My
in
lord,
terms of jurisdictions?
As a court, please, my lord, we don't want to interfere with my learned friend's cross-examination, but we don't see the relevance of this question, Lord. The issue of demarcation of jurisdiction has got absolutely nothing to do with this witness.
Yes, Mr. Mngmezulu, where are you going to?
I'm going to the place where this application was brought.
But we are in the High Court.
I beg your pardon.
Unless you want to submit that this case was unlawfully transferred from the regional court to the High Court.
That's not
pursuant to section 72C. If you want to allege that. But now we are in the High Court.
No, I'm not relating to that. The sequence of my question relates with section 43, and it must be understood by these accused persons that are before this honorable court to say, when I'm dealing with the issue of jurisdiction, I'll just demonstrate to the court that this application has been brought before a wrong court.
Okay, fine. What's your view?
I disagree, my lord. It's the same jurisdiction. I think the understanding of Mr Mngmezulu is absolutely wrong.
Okay.
Mnumzana Mngmezulu uthi bekafuna ukubonisa ukuthi lesiyasicelo besifakwe endaweni ekungasiyona uthi ubrigadier uyala uthi yena akaboni ukuthi bekafake lesiyasicelo endaweni ekungasiyona.
I'll leave that for argument, but still maintain that Foslorus Court, the magistrate of Foslorus Court, as per section 43, directing that this person should be brought before a lower court, it was referring to Foslorus Court where the offense was committed.
It's the same jurisdiction, my lord. That's the point that I'm saying. That's why the SPP in Boksburg also is the same SPP for Foslorus District Court. There's one SPP, including the control prosecutor. So it's one and the same, my lord.
Uthike manje mina ngiyafuna ukukwazisa ukuthi wena lesiyasicelo usifake endaweni ekungasiyona ngoba bekwamele icala njengoba lenza ke le Foslorus bekwamele abamangalelwa bayobulisa umantshi ngale eFoslorus uthi indawo efanayo ngoba umphathi ophethe abashushisi owase Boksburg uyena ophethe abaphathi abashushisi base Foslorus manje ukuya ngayo ubrigadier uthi indawo efanayo.
I'm glad I have authority to the proposition that I've just put it to you, which I'll reserve it for argument. May I proceed? Let's get into the requirement that a peace officer or the commissioned officer who is to execute the warrant, when bringing this application, must have a reasonable suspicion that a particular offense has been committed. Are you aware of that?
Yes, I'm aware. This is the application now for the warrant of arrest, J50.
I'm talking about the warrant of arrest.
Yes.
J50,
Yes.
section 43.
Yes.
Uthi uyazi nawo ukuthi umuntu womthetho uma yena efaka isicelo sayo lencwadi le egunyaza ukuboshwa komuntu kwamele abe nokusola okuthize ukuthi unecala elithize elenza ke luthi yebo ngiyazi.
And in terms of your evidence, you brought this application in October 2020, correct?
23 of October 2020, that's correct, my lord.
Uthi ukuya ngobufakazi bakho wena uthe lesicelo usifake ngo-October 2020 uthi yebo nge-23 zika October 2020.
And I'm referring to all 5 accused were already in custody when you brought this application, correct?
Yeah, but my lord, I think we dealt with this aspect. I think it must be clear that they were in custody for different matters. To try and create an impression that they were in custody for this matter.
Mr. Kininda, sorry sir, with due respect, I'm not creating any impression. I'm cross-examining you on what is prescribed by the law. I'm not giving my opinion here. What I'm saying is, when you approach the court, Boksburg Court, on the 23rd of October 2023, I didn't want to know the reason as to why were they arrested, who was arrested first. I was saying all 5 accused were already arrested, they were in custody. Is that so?
For different matters, yes, my lord.
Uthi manje uyavumelana nami ukuthi ngalesikhathi ufaka lesicelo nge-23 zika October 2020 bonke abamangalelwa akukandaba ukuthi bekade beboshelweni kodwa bonke abamangalelwa bona bebakade beboshiwe uthi yebo bebaboshiwe kodwa baboshelwa amacala angafani kungasiyile lecala.
Correct. The application that you brought on the 23rd of October 2020, if you understand what is a warrant of arrest, it talks about depriving somebody of his liberty. Do you agree?
My lord,
As a court case, my lord, we just want to the insinuation that if a brigadier knows something about a warrant, I think that we find that belittling and should be withdrawn.
No, I differ with my colleague. Brigadier Kininda is a very experienced police officer. The reason why I ask about Section 43, you can't do things because you have done it and you don't do it according to what the law prescribes.
Sorry.
If I'm talking, my lord, may I address it further before you?
Oh, okay, fine.
Fine. With due respect.
No, it's okay.
When this application was brought, if the brigadier was at that time able to distinguish between how warrants are issued and to him, when he brought this application, he was fully aware, because this is what the provisions of Section 43 and the case law requires, that he must exercise an independent opinion. Hence, his capabilities are expected when bringing this application. I cannot bring bail application not knowing what are the tests for bail application, what are the reasons for the refusal of bail, or what would be the reasons for granting bail. My submission is that in terms of what is required by this provision, especially case law, in Maposa's case, it reiterates the aspect of an independent opinion to be exercised by who? By the commission officer who's executing a warrant of arrest in terms of Section 44 of the Criminal Procedure Act. He must answer questions relating to this application that he brought for the arrest of these people.
Yeah, but I'm not interfering. Mr. Brigadier Ginenda says you and him have a different conceptual understanding of Section 43. Is that correct?
that's correct, my lord.
Let's read Section 43.
Thank you.
Because he says we don't have the understanding which he has.
Let's read. Can you
So
read it for me?
who's got Section 43?
Manje ke uma kuchazwa kuthiwa ingathi ummeli nobrigadier banokuzwisisa okuhlukile ngaleyo mthethosekelo okukhulunywa ngawo waka 43 oyikuthi
There's no subsection you want. You just want Section 43, sir.
uya ngobrigadier yena uwazi kanje
Hello?
Subsection
uMnumzana
1.
Mngmezulu uwazi kanje.
Section 43, subsection 1.
Correct.
Mr. Council is going to read it out.
Not me.
I'll read it out. The heading is warrant of arrest may be issued by magistrate or justice. Subsection 1 of Section 43. Any magistrate or justice may issue a warrant for the arrest of any person upon the written application of an Attorney General, now Director of Public Prosecutions, a public prosecutor or commissioned officer of police. Then subsection A, which sets out the offense alleged to have been committed. Subsection B, which alleges that such offense was committed within the area of jurisdiction of such magistrate or in the case of a justice, within the area of jurisdiction of the magistrate, within whose district or area application is made to the justice for such warrant, or where such offense was not committed within such area of jurisdiction, which alleges that the person in respect of whom the application is made is known or is on reasonable grounds suspected to be within such area of jurisdiction, and subsection C, which state that from information taken upon oath, there is a reasonable suspicion that the person in respect of whom the warrant is applied for has committed the alleged offense. Subsection 1 in capital A, notwithstanding any other law, an application for a warrant under this section in respect of the offenses listed in section 21 in brackets 1A, A to D, may be made to any magistrate or justice, irrespective of whether or not the place of execution of the warrant or the place where the alleged crime has been committed falls within the jurisdiction of such a magistrate or justice. Subsection 2, a warrant of arrest issued under this section shall direct that the person described in the warrant shall be arrested by a peace officer in respect of the offense set out in the warrant, and that he be brought before a lower court in accordance with the provisions of section 50. And lastly, subsection 3, a warrant of arrest may be issued on any day and shall remain in force until it is cancelled by the person who issued it, or if such a person is not available, by any person with like authority, or until it is executed.
Thank you.
Now, what is the problem?
The the question from the court, I just want to get it clear. If does it relate, the question of the court, does it relate
Now it relates
to the
both-
difference between
It relates to both of you,
To
because
both of
me
us.
listening to this section being read, there is no problem. It's clear as water. What should happen?
it is clear?
So what are you saying Brigadier Ginenda did not do in pursuance of section 43, subsection 1? What did he not do?
All
So
right.
that we all know the
Okay.
dispute.
If I'm understood very well,
Yeah.
because I'm trying to run away from the fact that a witness will say, I'm creating an impression. Let's just put it straight and clear forward. Warrant of arrest, it deals with somebody who is not in custody.
No, that's not how I understand the law. I kill somebody today, and Inspector Nisi arrests me and puts me in custody because he's got evidence that I've killed somebody. After 3 weeks, Inspector Nisi hears that, he killed another one in Klipspruit. I'm inside. He goes and effects a warrant of arrest in respect of that other one. What's the problem?
My Lord, I'll differ with the court.
Okay,
I'll
fine.
differ with the court. I'll make submissions as well.
Okay.
Because there is also a procedure in relation to the requisitioning of a particular suspect or an accused person. Yes. Hence, a scenario in terms of what the court is now making, it's relating to it actually goes to the meaning of what is arrest. It will actually go to the meaning of what is arrest, because the logic on this application, because there's somewhere in this provision that says a person is reasonably suspected to be residing somewhere, if I'm not mistaken. But when an application is brought by an officer who is fully aware that this person is not in Tembisa, this person is Modapi, it's clearly misrepresentation of facts. Because if you look at the J50 that we talk about, it does not bear the date, the address in which the suspect is at the time of the application was brought. That's the reason why I'm saying...
So you're saying Brigadier Gnena didn't specify where the suspect...
That's correct.
That they are in Modabi, as you say.
That's correct.
Sir, what specificity did you annotate on the warrant?
My Lord, insofar as accused 1 and 2, well, let me start with 1, my Lord.
Yeah.
I've said address unknown based on the events that had unfolded that time.
Okay.
And I've explained that in my evidence in chief and during the cross-examination last year, my Lord, in the issues of the address and the bail application, my Lord.
Manje ke kuleya ncwadi egunyaza ukuboshwa kwabantu uthi ke wena inkosi yenkantolo yabuza ukuthi uye wabhala yiphi address ke yakamangalo loqala uthi ngiye ngabhala ukuthi address angiyazi njengoba bese sengichazile konyakenye uma singiphana ngobufakazi bami futhi ngabuzwa nemibuzo nakhona ngachaza nalokho.
Yes.
And I'm not sure, my Lord, whether Mr Mngmezulu is insinuating that a prison is a residential address, because it's clearly asked on the J50 application, on the warrant, address, which is a residential address. You can't now put a building, correctional services as a residential address. I've never seen that.
Manje ke anginaso isiqiniseko sokuthi mhlawumbe uMnumzana Mngmezulu uchaza ukuthi ijele yindawo ukuthi mhlawumbe ingasetshenziswa njengekheli, ngoba mina angiboni ukuthi ngingabhala ikheli ngithi lo muntu usejele usekaboshiwe ngalesikhathi ngifaka lesi sicelo leso.
Mr. Kininda, you don't even understand yourself. Listen to this. On the 30th of May 2020, first time we met SB in Vosloorus. You allege that he made a confession. That's your evidence. Immediately, spontaneously, you look for somebody who can take a confession. And you knew at that time where was Sibiya kept.
But that's not correct, my Lord. On the 30th, that was the first time accused number 1 was arrested insofar as the drug dealing matter. So that was the first time he was arrested. It was before he was even incarcerated officially, in other words, being detained in the holding cells.
No,
manje mina ngithi kuwe ubaba uMngmezulu uthi kuye nge-30 zika May uma uhlangana nomangalelwa uSibiya wena uhlangene naye eVosloorus bese uthi uye wafuna ukuyozigunyulula la ukuthi uye wafuna umuntu bese ke kwagcina seyikuthi umangalelwa useka yokhuluma nje kanjalo uthi cha mina ngithi umangalelwa nge-30 ngalesikhathi bengiqala ukuhlangana naye ezoboshelwa leliyacala lokuleyidakamizwa akusukuthi umangalelwa ngaleso sikhathi bese sekaboshiwe.
And my Lord, the issue of getting, as Mr. Counsel is suggesting that I've made arrangement for spontaneously for someone to obtain this confession, that's the best practice. You try and get someone independent to document the confession. It is done that way, so that there's no issues of compromise or having interest in the matter. That's how it's done. There was nothing spontaneous about it.
Futhi njengoba ukhuluma nangokuthi ngiye ngathola umuntu ngaso leso sikhathi uthi vele into ekwamele yenziwe ngoba wena usuyazi ngecala kwamele uthole umuntu ongenalo ulwazi ngalelo cala oyikuthi uzokwazi ukuthi athathe istatement salomuntu ofuna ukuyokhuluma.
I don't want to rush you and you don't want to rush me. I'll get into that aspect of the procedure of how to take a confession. But my concern is when you met Sibiya for the first time, you questioned him to the extent of explaining his constitutional rights relating to this case. I'm not talking about drugs cases here. I'm talking about the murder of Senzo Meyu. You allege that he made a statement and immediately you took a decision that this person is confessing. Let me do the formalities. My concern is when Sibiya was already arrested on a J50 by Sergeant Mkhula, he was already under arrest.
I don't understand what is the question, Madam.
Let me repeat it for you, because you tend to explain things that you don't even understand yourself. The question is, when Sibiya was arrested on a J50, warrant of arrest applied for by Sergeant Mkhula, when he was brought to you on the 30th of May at Vosloorus, he was already under arrest.
My Lord,
Mr. Cortes Morot, I think the counsel owes the witness courtesy in cross-examining him to say that he explained things that he doesn't understand. I think it's simply rude, overbearing, and we submit that part should be withdrawn.
Yes, Mr. Mngmezulu, let's hear you.
I would say, I'm glad if my colleague can pick up that. But if that is done by this witness, I'll make an example of what he's saying. Mistakenly, I've uttered words and said, you read the rights of the accused. Out of insinuation, he said, no, I didn't say that. I understand what I was saying, and he better understood what I was saying. He said, no, I explained the rights, not I read the rights. So I'll take him according to the attitude he wants to address me on. But as long as he's going to maintain the decorum of this court. The question that I'm still maintaining is, I'm going to establish and prove before this honorable court that when this application was brought on the 23rd of October, when it was brought, it was unlawfully granted or unlawfully obtained on the 23rd, because this accused person was already in prison. What is of pivotal importance is here, what do you submit as facts to the magistrate who's going to grant or issue that warrant? If the address appears to be unknown, obviously in the mind of the presiding officer will say it must be circulated for this person to be arrested. Then what to go to section, I'm trying to explain this so that we are in the same picture, Your Worship, my Lord.
You are not with this witness.
No, in terms of the law. But with this witness, that's why I'm...
He also says in terms of the law, you are not in the same picture. Am I correct, sir?
Absolutely, that's what I'm saying.
That's how I understand.
Yes, section...
What, Mr. Mngmezulu? Otherwise, we're going to be here until Mandela is resurrected. Why don't you put your version of what you are arguing the law is going to say and let this witness respond to that?
My Lord, I'll do that.
Because now you're putting a version,
I'll do that.
A snippet of a version, and he says to you, no.
I'll do that.
I didn't know where his address is, because I remember you saying you guys went down to go and check Nongoma, and he was not known there.
Correct. He was known, but he comes
You see, my Lord, look at this. Look at this. Look at this. That's why at some stage when I address the court, it will be like I appear to be sarcastic. No, my Lord, the evidence of supporting this witness, to say he went to the extent of looking for this witness, the witness that was already incarcerated, it's a redundant application, especially for section 43.
No, it's not.
I'll submit
because
it.
He says they were going to check his residential address.
Correct, ma'am.
That's what the law says.
For what?
You arrest a person. No, Mr. Mngmezulu, please. Otherwise, we're going to be here.
My
you
Lord.
arrest. Oh, no, wait. Let me tell you my experience. You arrest a person, and then he wants to bring a bail application. He's inside the cells in jail.
Yes.
And then the state says we are opposing the application for bail because we want to ascertain the residential address of this accused. Is that not
Yes.
so?
It is so.
And
Madam.
then you leave them in the cells, you go to Nongoma. That's
It's-
what he says.
that's
And
a
he says
different-
when he got to Nongoma, he went to a particular address furnished by the very witness.
He was actually with us, my lord.
Oh,
I
he-
booked him out and I drove with him.
And then they
to
said, we
Manama.
don't know this man.
They said they know him, my lord, but he comes on regular
Oh, I see. Fine.
visits.
It's even worse. The applications are not the same.
Okay, what else,
Application for
Mr.
bail
Mngmezulu?
application is not the same as the warrant. A warrant of arrest, my lord, let us be honest. Section 40, which deals with the warrants with or without a, that's when you deprive a person his freedom. Literally, that means you deprive the person
If he
his
has
freedom.
transgressed the law.
That's correct.
If he has not transgressed the law, you deprive him of his freedom. You're right.
Yes, you can deprive him even if there are allegations that cannot be founded at a later stage.
fine.
Once they withdraw charges or he gets acquitted
Okay.
or whatever.
So
But
what else do you want to put to this witness?
you know, the reason why I had to deal much on Section 43, I want to make fruitful, I'll put it that way, fruitful submission during my argument.
Okay, fine. Are you through now with
Accused
Section
number
43.
1 and number 2 were already arrested. And my lord, I don't want to remind the court about the attitude of the court towards the defense and the attitude of the court towards the witness, because that will also constitute unfair trial.
what's the attitude now?
No, even that, I don't want to go back to the records, my lord. I'm just checking when the witnesses are testifying, what is the attitude of the court? May I request the court to remain impartial?
I'm
May I
I'm
request, if the
impartial.
court, sorry, my lord.
I'm impartial. The only thing I'm doing in this court, I'm quoting the law as I understand it.
I've indicated
That's
earlier
all.
on. I've indicated earlier on when I was cross-examining Mokgoatlheng. I said after the examination of Gininda, I'm going to bring an application under Section 371 to make it
317.
317,
Yes,
a
I
special
know the law.
entry.
317.
Yes, a special entry
Yes.
because of what I've picked up during.
Okay, no problem. You're
Yes.
at liberty to do that.
Hence, I'm saying my problem is with the application. Let me just put it this way. When you were after Sibiya and Danzi, after Sibiya and Danzi were charged for the Senzo Meyiwa case, there were so many rights that were explained in relation to 636 during their arrest. You remember that?
My lord, I remember, but I would like to start on the aspect that the state advocate objected on. I think, with utmost respect, I don't believe I've treated Mr Mngmezulu with disrespect. The fact that I differ with him with regard to the version that he's putting based on the evidence that I have in court, I mean in the docket, is not a sign of disrespect. But I've never spoken to him with any disrespect, and I would like him to treat me the same. I'm here to assist the court. I will answer him insofar as the question that he wants to know, and there's no reason to get emotional on this. Let's just do the business of the day, be professional about it, and move on. That's all that I want to ask him.
Brigadier uthi-ke ithi niqale la ubaba uBaloyi uye wasukuma ethi kunento afuna ukuyiveza, uthi ngithanda ukuveza lana nami ukuthi angisukuthi umnumzana uMngmezulu angimhloniphi, ngiyamhlonipha nanoma ngiphendula ngimphendula ngenhlonipho njengoba naye sekachaze ukuthi ubona ingathi angikhulumi naye ngokumhlonipha. Uthi cha, lokho akukho njalo, mina ngicela ukuthi sibe la sixoxe lolu daba olusilethe la, siyenze ukuthi lelicala liqhubeke, sikwazi ukuthi sisize inkantolo, sisebenzisane ngokuhloniphana. Uthi ngiyamhlonipha naye akangihloniphe, sihloniphane inkantolo.
I will refrain from such a conduct as long as we are in the same path. And this is not a condition. I'm just saying it, and I withdraw if I offended you. but let us take each and every question and answer in a way that will assist this court to see if such confessions were taken properly.
Yes, I agree, my lord, but in answering that, I cannot agree to things that I see are intending to create a wrong impression to the court. That's what I'm here for. And if I point those things out, Mr Mngmezulu must understand that I'm simply here to assist the court. There's nothing personal about it. I'm raising what I'm raising based on the investigation that I've conducted. It's nothing personal. And if you want to challenge me with that and point me to another direction, if of course the facts are there, I'll concede. But if the facts are not there, I can't concede to something that is wrong. But that is not meant as a sign of disrespect. It's what we are here. We are here for that, my lord.
Mnumzane Mngmezulu ke uthi ngizoyeka ke lokho njengoba uthi sihloniphane, ngizoyeka ukuthi singahloniphane, sizohloniphana, kodwa uma ingabe mina nawe sizovumelana kwizinto ekuthi ngiyazibuza, ubrigadier uma iphendula uthi yebo asihloniphane, nami ngizoyenza ukuthi ngiphendule imibuzo ngalendlela uyibuza ngakhona, kodwa uma ingabe ikhona indawo ekuthi ufuna ukungisa kuyona ekuthi mina angivumelani nayo, ngeke ngivume, ngizoyenza umsebenzi ukuthi mina bengikade ngiphenya kuleli cala futhi ngisize inkantolo ukuthi inkantolo ibe nesinqumo ekuthi yasithatha. Angizanga la ukuthi ngizothatha izinto ngenhliziyo, asebenzisane ungibuze ngiphendule bese sikwazi ukuthi leli cala siqhubekele phambili.
Now, my lord, I'll come to the last question, but the first, perhaps maybe let me try and deal with what I remember what Mr Mngmezulu raised, my lord. The issue of the J50s, and this is my understanding, that's why I said him and I have a different opinion. We've now read section 43, I think it's clear as daylight. But secondly, the warrant of arrest or the J50 is a means of taking someone to court. It must not be construed as the violation of the rights of the person that has been arrested. In any event, the Constitution, my lord, section 36 has a limitation clause. Once this case is made and the warrant is authorized, what do? The person must appear in court. And the warrant of arrest is the means of taking the person to court, as it can be summons, any other thing. I'm not aware of any provision in section 43 that says if a person is in custody, you cannot execute a warrant. I'm not aware of that. It was a means that was before us. The case that they were facing, my lord, is premeditated murder. I mean, even if the person was outside, how do you go and warn a person outside to say you've killed the person X on this day, you must go and appear on your own? There's no way. It will amount to J50, my lord.
Uthi-ke ithi nichazele indaba le yamaphepha agunyazayo ukuboshwa kwabantu, mina angiboni ukuthi lamaphepha lawa ayewakhishwa ngendlela engekho emthethweni, ngoba mina umuntu nanoma engaphakathi kodwa njengoba ebhekene necala elibucayi ukufana nalo leli cala lokuthi uye wahlala phansi wacabanga ngokuyobulala umuntu othize, mina ngokwami ngiyazibuza ukuthi ke uya kanjani kumuntu nanoma engaphandle ufike uthi kuye ubhekane necala lokuthi wena uye wacabanga ukuthi uyobulala umuntu bese ngelanga elithize uye enkantolo, ngoba isizathu sale ncwadi le egunyazayo ukuthi umuntu aboshwe ukuthi lo muntu loyo ube nalelo phepha bese uyaya uyombopha, akusukuthi uye uyomcebisa ukuthi ngelanga elithize kwamele uye enkantolo. Uthi manje lokho yiko engifuna ukuchaza ngalo lelicala.
Lastly, my lord, on the last part that Mr Mngmezulu asked me, my lord, yes, they were right that were explained prior to the execution of the J50s on accused 1 and 2, insofar as the questioning that took place prior to the arrest. They were questioned at a certain stage on the 30th, and whenever we engage with them, constitutional right as prescribed and required to do so were explained to them. But insofar as the arrest, my lord, that took place, in other words, the indictment of them and the charging formally of this matter on the 26th, that was explained in terms of 14A, as is also prescribed, my lord.
Manje ke ithi ngiphendule lo mbuzo lo bengibuzwe ngawo uthi yebo amalungelo wona akhona ayikuthi ayewachaziselwa umangalelwa amaningi, kodwa ngaleli cala kuye kwafanele ukuthi simchazisele futhi amalungelo, ngoba lawayana bekwamalungelo welinye icala ngalesikhathi ezokhuluma futhi kube kwamele ukuthi simbuze simchazisele amalungelo wakhe ngaleli cala, njengoba la kuleli cala bekwamele siyenze ukuthi sithole le phepha egunyaza ukuthi aboshwe bese siyambopha ke, ingakho bekwamele simchazisele amalungelo wakhe.
Okay, you gave your own understanding of section 43. My question now is, in your affidavit, did you ever mention that accused number 1 or number 2 was arrested for another offense? Did you mention that in your affidavit?
I beg your pardon, just what is the question, my lord?
My question is, when you brought your application, it was supported by an affidavit.
Yes.
In that affidavit, did you state clearly that accused number 1 and number 2 are in custody or were arrested?
I'm not sure, my lord. I'll have to refresh my memory. I mean, I've made that application in 2020. The important thing, the background of the case that was stated, I know that the evidence insofar as accused 1 and 2 that I was making the application on, I'm sure I've stated that. But as to where they are or where they were at the time, one will have to refresh, my lord. But the defense has also the copy, and I've got, I can go through it if that's what they want, my lord.
Uye wabhala na kwi-affidavit yakho ukuthi abamangalelwa ngaleso sikhathi bebakade bekuphi noma bebakade beboshiwe, uthi anginaso isiqiniseko, kodwa ngiyacabanga ukuthi ngichazile kule affidavit yami ngoba ukuthi ngiye ngasho na ukuthi baboshiwe noma cha, lokho kuzofuneka ukuthi ngiye mhlawumbe ngifunde statement sami futhi, kodwa unaso ummeli nami nginaso, uma ingabe kuyavumeleka ngahle ngibheke bese ngiyakwazi ukuthi ngiphendule yebo noma cha.
And last, my lord, the application was not about the verification of address, so I just want to say this, it was about the J50. It was not a statement to say whether the address is positive or negative, or they're staying there, so it might be there in terms of the background of where they are. But even if it's not them, my lord, that was not the essence of the application. It was the evidence that I had and the request for the G50 authorization.
Futhi ke leso sicelo bekungasi isicelo sokuthi siyavumelana noma asivuma ukuthi ikheli labamangalelwa ilona noma akusilona, bekuyisicelo esigunyazayo ukuthi sithole igunya lokuthi siyobopha abamangalelwa. Yiyo inyinto emsemqoka ebengifuna ukuyichaza.
Let me just put it to you by saying, if that is the statement you made under oath in a 198 statement, if that is the application, that's the statement or affidavit in support of an application, I'll ask you to go through that statement. But in the meantime, I just want to put something to you, then you can comment on that one. If you brought an application, that's what I'm putting to you as a matter of law. If you bring this application and state clearly in your affidavit that accused number 1 was in Modabi and accused number 2 was at Pukeng police station, I'm making an example. The magistrate court was not going to grant that application. Do you agree?
No, I don't agree, because you are now, I don't know, I don't agree, my lord.
Uyavuma nawo ukuthi ngalesikhathi wenza le sicelo lesi salencwadi egunyazayo ukuthi abamangalelwa baboshwe, kube uye wachaza ukuthi ummangalelo oqala mhlawumbe umzekelo use Moda B, ummangalelo wesibini yena mhlawumbe use Pukeng police station, ngaleso sikhathi leso sicelo besingeke sivunywe uthi cha, lokho ngiyaphika.
Perhaps counsel, my lord can refer me to a section that says if a person is incarcerated, a J50 warrant cannot be issued. Then perhaps we can close this matter, because I'm not aware of such.
Mhlawumbe ke uma ummeli angangibonisa umthetho othi uma engabe umuntu esekaboshiwe akwamelanga ukukhishwe incwadi egunyazayo ukuthi lo muntu angaboshwa kwelinye icala, mhlawumbe singakwazi ukuthi sivumelane noma siqhubekele phambili.
Yes, it's fine. You can say that, or you can ask for that law, but I'm still putting to you that the proper way of securing the attendance of these accused persons who were at that time of the application were in custody was to requisition those accused to the relevant court for their first appearance. Do you agree?
As a please, my lord, that question is unfair and it's wrong. The witness has...
But they haven't appeared in court anyway.
Yes.
How do you requisition?
Yes.
As I understand the law.
Yes. In any case, the witness has already said that A warrant is a way of securing the attendance of a person in court, and Section 38 clearly states, my lord, that the method of securing the attendance of an accused for his or her trial shall be arrest, summons, written notice, and indictment in accordance with the relevant provisions of this Act.
That's the only way.
The question that my learned friend is putting to the witness is
That's Section 38, sir.
Yes, Section 38.
It doesn't talk about requisition. Hello? Does it
Yes.
talk about,
No, it doesn't talk about
does it talk
requisition.
about requisition?
No.
Okay.
It talks about a summons.
Yes, someone's fine. Section 72(5)(c), I think. Hello?
I was listening to
No, I'm
the court.
quoting the law.
I didn't hear what the court was saying.
No, you know the law. I was saying to the gentleman who's saying he talks about the summons. There's a way it deals with what the summons is.
Yes.
Yeah, fine.
Mark, I'll still maintain, I'll get into the part where, even if you say there's no such a law, my concern is when the application was brought, there was an information that was not disclosed fully to the presiding officer.
My lord, the address, how is it relevant to the evidence? What the presiding officer and the prosecutor, who obviously both of them signed the warrant, needed to know the strength of the case, whether such warrant can be authorized. And the decision was taken based on that, and as well as the indictment that I referred to. So the issue of address, like I've said, my lord, if counsel perhaps can say to me, this is a section that says you cannot get warrant of arrest or warrant signed by the magistrate when a person is in prison are unlawful, then we'll find each other. Because like I'm saying, I'm not aware of such, my lord, and there's no law that says that.
Okay.
And secondly, lastly, my lord, as I've said earlier, warrants of arrest are one of the means to bring people to court.
Uthi-ke manje mina ngiyakutshela ukuthi ngalesikhathi wenza lesi sicelo kunezinye izinto ongazivezanga kuleya ncwadi egunyaza ukubopha umuntu. Uthi anginaso isiqiniseko sokuthi ukhuluma ngani ngoba ngiyacabanga mina ukuthi nencwadi egunyazayo ukuthi umuntu aboshwe incwadi ezoyenza ukuthi lo muntu sikwazi ukuthi ayovela nasenkantolo. Uma ingabe mhlawumbe ungangibonisa umthetho oshoyo, mhlawumbe singakwazi ukuthi sikhulume into efanayo, kodwa okwamanje mina ngisamile ekutheni incwadi leyana ngiyifake ngendlela esemthethweni, ingakho iye yavunyelwa nayo inkosi yenkantolo.
The J50 warrant of arrest, I'll just pass the issue of address, but it is relevant, and I'm going to make submissions on that irregularity in terms of granting that or issuing that warrant of arrest. Now let's get into your statement. I think it's A198, if I'm not mistaken. Your affidavit. Are you in possession of that, sir?
For the application for the J50 warrants?
Yes.
No, I'm not, my lord. Can I just check? I'm not, my lord. But my lord, to say the application, the issue was irregular, I disagree. There's no
That's
such.
for the court to
I
decide, my lord.
No, it's not for this court to decide. It's for
Yes.
you, Mr.
Yes, I'll make
Mr.
submissions. At the end of the
Mngmezulu, to
day.
bring an application reviewing the decision of that magistrate to say that when he granted that warrant on application by Brigadier Belinda, the law was not permissible for him to do that. Not the witness himself. Unless you accuse him of fraud, fine. Fine.
Are you in possession of that?
Yes, I am.
Am I correct to say it's A198?
Yes, 198. That's correct, my lord.
Do you need some time maybe to check if the aspect of the address has been canvassed on that affidavit?
I can, my lord, but like I said, I can. If
Yes.
defense wants me to do that, but I've already dealt with the matter.
Now, I
The
just want to
issue-
place it on record, Mr. Kininda.
I will, yes, my
Yes.
lord. But what I'm saying, what must be clear, there is nowhere where the issue of address is a prerequisite for getting a J50. You don't get J50 unless you are saying the person, because even if the address is wrong, if the elements of a crime are not there and the person didn't commit that offense, why would the judiciary sign the warrant of arrest? The basis of this application and authorization was based on the evidence collected insofar as accused 1 and 2 are concerned, my lord. But I will check if I...
No, this court wants to know what's inside that warrant.
Usiphethe na
That
istatement sakho.
application, the court must also know.
Yes.
Usiphethe istatement sakho uthi yebo ngisiphethe uthi ungasibonisa na la ukhulume khona ngekheli likamangalelwa uthi lokho ngingakwenza kodwa angiboni ukuthi kumqoka kanjani ngoba awukho umthetho ongivimbayo ukuthi uma ngingenalo ikheli likamangalelwa ngingahle ngifake lesicelo manje mina ngibona ukuthi lesicelo ngasifaka ngendlela esemthethweni uthi ngakwenza lokho na njengoba seka sibheka istatement sakhe efuna leyo ndawo la ikuthi kubhalwe khona.
But you've got to read that statement, sir. Were you suggesting the same, Mr. Baloi?
No, I want to point out that my learned friend wants to use a statement that he hasn't proven as yet. He must first prove the statement, then follow
No,
the
it's okay. He doesn't have to prove it if he wants this
Correct.
witness to read it under cross-examination. Okay. That's the law.
Well, we still maintain that if you want to cross-examine on a statement, you first have to prove it.
No, fine, but not under these circumstances because we are not at idem. Just read that for everybody to know what is in that document.
All right, my lord. So it says, I, the undersigned, Bongani Nicholas Kininda, state under oath, as follows in English. I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I am currently stationed at the National Commissioner's Office as the Commander for Cold Case Investigation Unit of the National Commissioner, with the rank of a colonel and the service number. I've mentioned the service number, so that's the telephone number. That's paragraph 1, my lord.
Na yike
No, no.
iparagraph yokuqala
Let him finish first.
as the court places thank you my lord.
I am the lead investigating officer of Phosphorus 636-10-2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 20:30 and 2100 hours. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that 2 black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witnesses stated that one of the accused was carrying a firearm, purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as a tall, slender, neatly shaven and dark in complexion. It is stated under oath that during the robbery in the same house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased Meyiwa on close range in his chest and exited at the back of his body. The second accused focused on the rest of the witnesses. In the process, one of the cellular phones belonging to Ms. Kelly Kumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects wearing specific clothing, among others, a hoodie, were standing hidden away about few meters from the crime scene prior to the incident, appearing to be typing on their cell phone. It is stated that the suspect fled on foot and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identities were compiled through witnesses of this suspect. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 8:30 and 2100 hours, my lord. The deceased was declared dead on arrival at the hospital at 21:15. Investigation revealed that the cell phone which was robbed was picked up through cell phone towers until the signal was lost during covering the area of Phosphorus Hostel. The said cell phone was never recovered to date or ever switched on again. The evidence explained herein under will indicate that the planning of the offense and gathering after the incident took place at Phosphorus Hostel. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery or robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa. The suspect in question are as follows. 3.1 Mokgoatlheng Themba Spear. He was first linked to this offense by means of witness statement under oath. The accused boasted to individuals closely associated with him in KZN homelands as to his involvement, together with Mafika, herein as under suspect 2, Carlos under suspect 3, Mapisa suspect 4, and Ngani suspect 5 into killing of the deceased. A dispute ensued between the individuals and the closely associated individual disclosed to the ACPS the admissions these accused made to them. The accused was further linked with circumstantial evidence wherein minutes after the incident made disclosure and remarks at a family gathering he attended in Phosphorus as to the killing of Senzo even before the death was reported in the media. He is further linked by means of a formal confession he made to the Commission Independent Officer on the 30th of May 2020. The suspect further made a formal pointing out the sequence collection prior to the incident, the guarding of the outside of the house during the assassination, and the dropping of the accused at the cell phone tower referred to herein above. Second one, 3.2, Bongani Sandison Tanzi, nickname Mafida. He is linked to this offense by means of certified sworn statement he made to the witnesses and an identikit compiled through description of witnesses. He was identified as the person with the hoodie who initially stood outside of the house prior to the incident and running away after the incident. The involvement of this suspect was mentioned by suspect 1 herein above as equally involved in the killing of the deceased to the family of suspect 1. The suspect was traced through information received and he was confronted with the evidence available against him. He was amongst others confronted with the clothes he was alleged to have worn and compiled identikit. During the questioning and the subsequent search of the premises where ammunition found for which no license was produced. The suspect was arrested for this offense. Hereafter, the suspect indicated his eagerness to confess as to the involvement in this matter. The suspect made a confession to a commissioned officer on the 19th of June 2020 and later made a further confession in the presence of his attorney to a magistrate in Boksburg Court on the 24th of June 2020. Through the confession, does it appear that his suspect is the suspect that was described as a tall, slender build which came into the house. 3.2, Toby C. Friend's nickname Carlos Nobe. He is linked by means of sworn certified statement in the docket referred to herein above. The involvement of this accused was equally explained in detail in the confession by suspect 2 above. Through investigation of this information contained in the confession, further evidence under oath was obtained as to the suspect's real name depicted above. It was established that the suspect was sentenced prisoner serving 35 years imprisonment for the murder committed in 2015. Ballistic test revealed that the same firearm used in the murder for which the accused was serving his sentence were used in the murder of Senzo Meyiwa. Upon the accused's arrest for the 2015 convicted murder, a cell phone was seized in his possession. The cell phone downloadings of this cell phone were done. The photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident as the accused carrying the revolver upon entering the house. Photos downloaded taken of the accused by himself or selfies match the description of the suspect who had a firearm with red locks, big eyes, and with the gold teeth. This is the suspect that went into the house, made a demand for cell phone and money. He is also the same suspect that shot the deceased in this matter during the struggle with him. Photos were actually found of the murder weapon used in the murder of Senzo Meyiwa. 3.4, Mthokozisi Ziphozonke Mapisa, also known as Mapisa. The suspect is linked to this offense by means of certified sworn statement and referred to herein above. He is further linked by means of confession he made to a private person, a close friend, about his involvement in this matter. This confession came about in that the suspect requested this private person to establish reasons why suspect Mafiga was arrested. The information disclosed was that the suspect Mafiga was not only arrested for ammunition but also for the Meyiwa murder. Upon the private person return disclosing this information to the suspect Mapisa, did Mapisa instruct the private person to return to and inform Mafiga, that is accused to not to disclose Mapisa's involvement as Mafiga will be assassinated. It was during this discussion that the suspect Mapisa confessed to the private person his involvement in the matter. Investigation revealed that the role of this suspect was to guard any unexpected people who may come in or outside the house. He was also armed with a small firearm. 3.5, Mokgoatlheng Nkani, also known as Nkani. The suspect is linked by means of sworn statement by witnesses referred to above. He is linked to a car that was used as a getaway vehicle, which is a silver VW Polo. Evidence also revealed that he drove the car with the suspect to the same scene and back to Phosphorus Hostel after the incident. His role was to remain and guard the getaway car during the commission of the offense. The confession of Mafiga, insofar as the usage of the vehicle refers to, is supported by independent witnesses confirming that this accused was seen driving the said vehicle prior and after the committal of the murder in the company of the referred suspect. The above suspects are also known to be hitmen for taxi wars. The said suspects were traced and found on different locations and occasions where they were warned according to their constitutional rights in terms of Section 35, Act 108 of 1996 by me, and questioned for these incidents. Some of the suspects made confessions to the independent commission officers as well as the magistrate as indicated above. Others made confessions as they were showing off to private persons who were well known to them after the incident, but on different occasions as well. Evidence by means of sworn, corroborating, and independent witness statements establishes a causal link between the offenders and the offense of murder, robbery with aggravating circumstances, possession of unlicensed firearm, and the unlawful possession of ammunition. The Director of Public Prosecution, Gauteng Division, on the directive of the National Director of Public Prosecution, issued, after careful consideration of the presented evidence, that the above 5 suspects in paragraph 3 must be arraigned for murder, robbery, and aggravating circumstances, as well as possession of unlicensed firearm and ammunition. The instruction are attached with the statement as B and G1. I hereby apply for the warrant of arrest for the following suspect on the above indicated charges on this paragraph. Then it is the names of accused 1 to 5, my lord. Then it's the oath, and the statement was commissioned on October the 3rd, 2020, the 3rd of October, my lord.
Naso-ke istatement sika-Brigadier Udinayina ngamafuphi istatement lezi sichaza ukuthi uyenzeni yena ngaphambi kokuthi aze azobhala lesi statement la ukuthi uyachaza nokuthi abamangalelwa bona bafakwa kuleli cala bayenzeni, futhi kunala ukuthi uchaza ukuthi umangalelo oqala uye wahamba wayekhuluma nobani umuntu bekade sondelene naye, ingakho ukuthi lo muntu loyo uye wagcina sekuthi uyotshela amaphoyisa, bese ke umangalelo oqala kula ebandakanyeka khona. Lo mangalelo esibini naye kunezinto ukuthi uye wazikhuluma ebekade ezikhuluma kumuntu othize naye ubandakanyeka ngaleyo ndawo, naye ukuthi umangalelo wesithathu uchazwa umangalelo wesibini ngalesikhathi ebekade ekhuluma egunyuluka laphayana ukuthi yena uthi bekayenzani kula, nawo umangalelo wesine naye uyachazwa khona lapho, futhi ngathi ikulesa statement sikamangalelo wesibini. Umangalelo wesihlanu yena uchazwa njengomuntu obekade naye ekhona, futhi uyena umuntu obekade eshayela imoto le bekade kuhanjwa ngayo ngalesikhathi kwenzakala leli cala leli kwenza liqale ingathi bekade kuyobanjwa nje inkunzi, kodwa kugcine seyikuthi kuyabonakala ukuthi bekungasi nje ukuyobamba inkunzi okujwayelekile, bekade kuthunyelwe noma bekade kunolwazi lokuthi kuyoyenzakalani khona lapho, futhi labantu laba bekade beyingxenye yokuthi leli cala leli liyoyenzakala. Futhi kuchaziwe nalana ukuthi umangalelwa ubekade owesithathu ubekade yena ngaphakathi kwicala ukuthi lenzakele ngo-2015 lokuthi nalo bekade sekuthi unikwe isigwebo seminyaka engama-35 la ukuthi ubekade ebhadla ejele, kodwa ke ubrigadier uthi naye uye wayenza uphenyo lwakhe, ingakho egcine sekuthi ubhala lesi statement. Ngamafuphi nje akusiyonke into ayibhalile, kodwa bengizama nje ukuthi ngithi ukusibamba laphayana nalaphayana lesi statement.
My lord, I just want to correct also the date in which the statement was signed and commissioned. It's actually the 23rd of October 2020. Sorry, not the 3rd, so it's 23rd, 23 October 2020.
Thike futhi enye into idate yale statement la si signwe khona akusiyi 3 yi-23 zika October 2020.
Yes, Mr Mngmezulu.
Thank you.
Mr. Please, Molo, just before my learned friend cross-examines, we just want to caution my learned friend against this course of cross-examination that is embarking upon. We must keep in mind that we're busy with a trial within a trial. And the purpose of a trial within a trial is to insulate the proceedings from the merits and to protect the interests of the accused should he wish to testify in the trial within a trial, not to expose his flanks to cross-examine on the merits. Now, my learned friend is canvassing issues which pertain to the merits. And should his client now decide to come and testify in the trial within a trial, which must keep in mind that the trial within a trial is concerned with the admissibility of the statements that were made by the accused. Now, my learned friend is now canvassing the merits, which will expose his client to cross-examination on the merits, should he or should both of them decide to testify in the trial within a trial.
Mr. Mngmezulu is an experienced advocate. He knows what he's doing.
That's correct. In response from the submission made by my colleague, I am so grateful that he mentioned the aspect of protection of the client's rights. But what is very important in relation to the contents of his affidavit will be injected also when the argument arises on the admissibility of confession, the extraocular statement made by.
They're not admissible against another accused.
That's correct.
Yeah, we know that.
Yes.
And by the way, just so that there's no misconception,
Okay.
what Ginanda is reading there is hearsay.
That's correct.
Please.
That's correct.
So, hey, Judge Lay, there's about to get evidence, what? It's hearsay. It's not admissible.
Yes.
But I said he must read it because you were insisting that there are certain contents there which render that application unlawful, as you
correct,
said.
my lord.
Okay.
As I've indicated, my lord, also that the gist of these proceedings relates to the admissibility
Yes,
of
yes.
the confessions.
That's okay.
Where does the I'd say, what factors will the court consider at a later stage if some of the information that is important to the argument that an extraocular statement was made which resulted to the arrest of other accused persons. May I proceed?
Yes.
Just to confirm, my colleagues are requesting a short
What's the
argument.
time now?
It's 12 o'clock.
12 o'clock.
It's 5 to 12, my lord.
Until when?
5 past.
5 minutes.
Until
Okay,
5
quarter
past
past 12, we come back.